So, what's the difference between a case that settles for $100,000 and one that settles for 3 million? What are the factors that actually drive value?
It's typically who the harasser is. In any case, you look at the wages. You're entitled to lost wages. You're entitled to emotional damages, and you're entitled to punitive damages, right? Plus attorney's fees if you're successful at trial. What drives it is who the harasser is. If it's a CEO, if it's a high level um, supervisor, if it's a law firm partner. And the reason why is they typically, supervisors or people in that power should know better.
Hmm.
And if you go to trial, the jury should realize that that person knew better and they would get hit with the punitive damages. So that's typically the scarier part for the company. And or they'll find out that the harasser did it before. I've had cases where I'm like, oh, it's this CEO again. That comes out, and if a jury would find out, like, look, it happened once and you let it go, it happened again and you let it go, and they're in trouble. So those are the things that drive. Also, if you experienced a lot of emotional distress, and that's something I never want my clients. I don't want to hear that every single day you were sexually harassed and you were going to the doctor, you're taking medication. I don't wish that on anybody,
Right.
but the emotional damages part, takes it takes into accordance as well. How often you went through it, how long you went through it, and whether you sought medical treatment or not. Not necessary, but that's a factor too.
So, walk me through what happens when, from the first phone call to your office to the day a case gets resolved. I mean, that's kind of a long, but give me the Cliff's Note version of what
Yeah.
happens, the whole process.
So the first thing we're going to do is we're going to get a timeline. We need a timeline because we're going to draft a set of facts, right, of what actually happened. A lot of times we will actually draft a lawsuit. We try and put things into federal court because federal court um, keeps the defense and the employer they behave a little bit better in federal court because they have to give you the discovery. They have to give you the documents you need, and it moves a little faster. So we'll draft an actual federal complaint, what it looks like.
Hmm.
If we can, we'll name the harasser individually. We'll name the company. I want them to see what this is going to look like when it's filed. So we do that, and we'll send it. We'll send we call it a letter that we represent the client, and this is the lawsuit that we will be pursuing if you don't not looking to resolve the case. We always try and resolve it before. We're only able to do that because we've litigated like almost 2,000 cases, which I don't think there's any competitor that is litigated. Most of them are not even half. So the defense attorneys, the insurance companies, they know we will litigate. You know, 8,000
Hmm.
cases, 2,000, almost 2,000 litigated. They know. Um, so we'll send that out, and we'll always try and mediate. We want it's. I find it's better for both parties to resolve it, and both parties move on with their lives. But we're not going to settle it for peanuts. There will be accountability, recognition. Maybe they'll put policies in place. So that's always the goal to try. But they have to, defense and the employer, they have to make a difficult decision. If they're going to throw peanuts at us, then we move forward. Then we move forward. We file it in the EEOC, which is a step you have to do before filing in federal court. And even though you file it in federal court, you do have your state and city your state and city laws that you sue under as well, because they're a little broader. And then we move towards litigation.